Hey everyone, welcome to another Fitz in Law School episode. We got a good one for you today. I'm trying to make these a little bit faster, a little bit quicker, because 20 minutes is a long time to not include any graphics and to be staring at my face the entire time. So I'm going to try to make these a little bit more efficient. But today we have a very important topic. Finals are coming up for me in like 3 weeks. So I'm just working day and night studying this moot court brief to try out for moot court. And so this perfectly fits into the subject of today, how to study. So how to study is an extremely important thing. And it's distinct with each class, and it's distinct with also each type of school. Studying in law school is going to be different than studying in med school. It's going to be different than studying in undergrad, unless you have like a super specific kind of an undergraduate degree in organic biology or something like that. And so because of that, it's always important to essentially learn how to study when you're going into these things. And this is going to be something, like I said, I've definitely mentioned this in previous episodes. This is going to be something that you adjust over those 3 years, depending on the subject that you're studying and depending on the class, depending on the needs of the class, all those kinds of things. So to start off, it's super, super important to understand what you're studying for. And that helps you calibrate how you're supposed to study. And so the first thing is essentially describing what a final looks like. And I know I've kind of touched on this a little bit in my previous episodes, especially like with the finals and everything like that. So I thought I would just go over this one more time, just in case anyone's just joining us now. A final is the a lot of times it's kind of the only thing that you're graded on. It's not like undergrad, and it's not like high school. It's not like any of these things. You don't have assignments that you're really assigned to. And the vast majority of the time, you're not called on in class. You're not really forced to recite any sort of information. Usually it's people who are either on call, and most of the time you're not, depending on how the professor does it. Or it's you raising your hand and having a question or offering another piece of the case or something like that. And so because of that, there's not much continuous demand for you to apply yourself until the very end, because the final is the only thing that's graded. Most of the time it's like 95% of the grade within that class, and then everything else is just like it's an exercise, or it's like a check mark. Okay, do this assignment. Did you do it? Fantastic. You get a check mark. You did it. They don't grade it for you. Like lots of times you get comments on it and stuff, but you're not actually graded on it. So it's most of the time it's participation. It's you actually being in class, and then it's the final. And so that's it. Maybe it's not the best system, but that's a system we got. So you need to learn how to succeed in this kind of a system. So the final is essentially, the vast majority of the time, most finals are going to be kind of the same thing. What they're going to be is a series of multiple choice questions, if any, 5, 10, maybe 20 multiple choice questions that are black and white, that are saying, there is a wrong answer and there is a right answer. And usually they have 4 or 5 possibilities. They really want to start modeling it after the multiple choice questions that you're going to get on the bar to make sure that you succeed, especially in California, since California has such a difficult bar exam. Every other place has like a 80 or 70% pass rate, and California has like a 60%, because the passing score you have to get it's something like 70% of the questions right, versus most other states you only have to get like 60%. And so it's just a more difficult kind of exam. And the fact that California has such an expansive legal system that, there's just a lot to know and there's a lot to learn. Plus California's awesome. So you have the multiple choice questions, and then from there, you have 1, 2, or 3 essays. And those essays are where, a lot of the meat and potatoes are for what you are actually graded on. And that proves the facts that you know about the cases surrounding the subject matter that you're being tested on. That shows how well you can synthesize these ideas and apply them to an actual fact pattern. That's what essentially like a little blurb or the the 2 or 3 paragraphs that they give you saying, all right, here's the situation. This guy does this, and then that happens, and then that happens, and then they say, So analyze the legal situation of X, or this person sues Y for some other, like for this crime. Is he going to win? Like those kinds of things. But essentially, it gives you a certain kind of fact pattern, throws in little curveballs and a lot of stuff about what you learned that entire semester. And it's a very interesting way, and it's a very interesting way to test things, and it's the exact way that you're going to apply this knowledge when you become a lawyer. So it's not a bad system. It definitely does obviously put a lot of pressure on the student. But it's law school. That's what happens. That's what you're going to do. So just get used to it. So that's essentially what a final looks like. And so because of that, you need to adjust your study habits accordingly. So the first thing you need to really know is you need to learn what you need to learn. And so by that, I mean there are, I kind of mean two things about this. The first thing is that you need to know what concepts are super important within your class. And number two, you need to know what the teacher cares about, because the teacher is going to be who is grading your exams. I don't think that TAs help that much when it comes to grading finals. I'm 99% sure that they don't grade them. That's only the teacher who grades them. Even in the classes that have 80 students, like they grade every single one of them. And so because of that, you need to understand the teacher's style. You need to understand what concepts they really hammer home in class and say, now this right here, this is something that's important because this is what all of civil procedure is based upon. This is what all of criminal law is based upon, this idea. And so because of that, you need to understand what you need to learn and what you need to take away from the lectures, from the cases, all these kinds of things. And so that you do that by going to teacher office hours. You do that, I didn't do that last semester, and I'm doing it this semester, and I'm not regretting it at all, because it's a great idea to understand not only how the professor thinks, but what you really should get from these cases. That means just in class saying, okay, so when we're talking about this on the test, how do we discuss that? Everybody knows that the test is the important thing. The teacher knows that everyone's freaking out about the test, and so they're going to support you in that. And if you don't ask, then what are you doing? Why are you wasting your time by wondering whether or not something matters? You need to ask these questions, because these are the important questions, because the grades are important and the final is important and all that stuff. So you need to learn what you need to learn. Number two, synthesize your learning. So that means that not only understanding what you need to learn, and then from there, really internalizing it. So how textbooks are really set up is that there is sections, essentially. There is a section in my criminal law that says, now we're going to be talking about bribery. And so when we're talking about bribery, there are big swaths of text that's essentially the narrative of the casebook that is talking about the subject of bribery. It's talking about where it came from, where the idea came from, and then how it's been developed. And then in those specific turning points of the understanding of that concept within the law, they have a case. And they have that case that essentially says, either here's the court that turned things around, here's where strict liability all of a sudden became a thing, with Justice Traynor, or here was the old way of doing things. And then once the case is over, the narrative continues and said, since then, things have changed. And then there's another case that essentially has the court talking about the old way and then saying, well, that doesn't work anymore, so let's do it the new way. So because of that, it's just a really, really good idea to not only get the cases down, but also get the narrative down to really understand the story. I like the story. The story really, really works well for me when it comes to understanding these concepts. And so that's why I really like cases, I really like the story, and I really like the narrative that's binding all these things together, because then you can really understand the development of the law. And if you understand that development, then I think it puts a lot more of a base under your knowledge, so that you can get that base of knowledge to really build upon your understanding. And so, you just need to kind of understand how this all fits together in order to really bring it to bear when the final happens. The third thing is understanding how to take the notes properly. Your notes are really, really important, and they're going to be what you're basing your outline on and what you're basing your understanding on, and especially during the lectures and all these things. So from that, I have a specific way of taking notes, especially when it comes to cases. So the big thing that I do when it comes to cases, and it's essentially the same system every single time, but it fluctuates just ever so slightly depending on the class. So what I do is I go and I have in big bold letters up top, I have the name of the case. And then in brackets, I have the section that case is associated with. So this is this case, and this is bribery, or this is this case, and we're talking about, specifically easements. And for there, we're talking about, easements, conservation easements. Like these things that are super specific, so that when you're looking through all your notes and stuff, and I use OneNote, which is a pretty good way, but I've also seen people have like one Word document, and the entire thing is in one Word document for like an entire class. So they essentially really know how to call upon or how to like search through the entire document really, really quickly, and that works pretty well. One of my classmates there, she actually used OneNote all of last semester, and I used what did I use? I don't even remember what I used. I used Word documents, I think, or something. God, it feels like 1,000 years ago. Or no, I handwrote all my notes. What am I talking about? So that's what I did. But then I typed up each one of the cases. So I handwrote all my notes, the surrounding notes. I typed up the cases individually, and then from there I took handwritten notes on those cases once I printed them out. Wasted a lot of paper, but I did pretty well last semester, so maybe it worked. But so the title of the case, and then from there the next line is in big bold letters also, the court that it's in and the year, and that's just for my own purposes because I like the organization of that. And then from there I do sections. So the first section I do is procedural history, and so that's understanding the pathway of the case before it came to the court that we're currently in. How did it get to the Supreme Court? What did people do? What's the issue that this court is deciding? All those things is super important. From there, the next section is the facts section. And so the facts section I put it in chronological order. And so the chronological story of this person did this, then that person did that, then that person did that. And that's how this case came up. And then from there, it goes to the procedural history and says, X sues Y. And that's always the first line that I start with. This person sues this person, because then you can tell who's the plaintiff, and then from there you can tell who's the appellant or the respondent. So facts. The next section is the rule section, and so that's also super, super important. The rule is what you should be getting from the case. It's what's the gist. It's why this case is in this particular section. This case was how the court decided that the warranty of habitability was implied within all leases. It's like this is the case that decided that. And so you want to know the name of the case, and then the rule that comes with that case, and then a couple of the facts, because that's what you need to know for the test. You need to know the basic facts, you need to know the rule from it, and the name of the case. Sometimes you don't need to know the name of the case. Sometimes professors are more forgiving about that. And so if you say, this is exactly like the case where the person did this and then this and then this, the professor's going to know what you're talking about. And so as long as you understand the rule of the case and the idea of the case, then usually they'll forgive that. And then from there, I have the reasoning section, and that's just essentially the dicta of why the court decided the way it decided. And then lastly, I have, for two of my classes, I have notes that's underlined, and then I take all my notes from there, not handwritten, but on the computer. And I do that in class. So the commentary the professor gives, I kind of add the commentary in there under the notes. For my IP statutory interpretation class, I also include the canons used. And so that's what the court uses to interpret the law. And the reason I do that is because that's what's super important within that class. And so if you adjust these things to what's important in that class, that'll really, really help you. And then the last thing, which is just a little bit of encouragement, is do the work. Just do it. I have the moot court team to try out for on Tuesday, and so because of that, I really, really wanted to go and get all my reading done on Friday. So I did, and I remember some of my friends texting me a few days ago and saying, "Wow, reading on Friday, that's crazy." And I was just thinking, what do you mean reading on Friday is crazy? Like, don't you want to get it over with so that you can relax during the week, or relax during the weekend? Like I don't know, but whatever, man. But do the work. You can do it. I know you can, and you're all going to do great. But I hope that this really, really helps you with studying, and I hope you take a couple bits of my advice, because I think they're pretty good. I think that next week we're probably going to talk about like the extracurriculars, because I'm trying out for moot courts. A ton of my friends are trying out for moot court and trial team. Just there's so many things to do, all law students essentially say moot court and trial team are sports for law students, because that's kind of true. Like law schools usually don't really have any dedicated teams. Usually it's the school itself, but not the law school. And so because Hastings is just nothing but a law school, it's just a little bit different. So I think that's what we're going to talk about next week. All right. See you later, guys.